percent of the damages are going to be attributable to the negligence of the other.
That's correct.
But the injury mitigation, and that's what my question is.
You're right.
Seatbelt safety contributed to the injuries. I am really unclear on how the math works. Could you help me understand that?
I think it's a good question, and I appreciate that, because we're not dealing with the fact that failure of the wearing of a seatbelt by the person who's injured as being, as we talk about, contributory negligence. I was not clear on that point. What we're talking about is that because there was a failure to have a seatbelt on, the injuries were increased beyond what may have been the injuries had they had the seatbelt on, and that's why we've drawn the law on the basis of it being a lessening of the damages. Let's assume that someone is injured and has a head injury in a vehicle, and as a result of that, they could go to trial, and the jury is recognizing their injuries being $100,000. But the jury has heard testimony from the doctor that says because they didn't have the seatbelt on, they received greater injuries than they would have had the seatbelt been in place, and that way the jury can consider what are those injuries. There'll be testimony about it, I'm sure, Mr. O'Neill, that you had a head injuries that maybe accounted for $50,000 of the value of the cloths that the person has, so the jury could consider, doesn't say it has to, they can consider this mitigation, a reduction of the damages from the $100,000 to the $50,000. That's a good question. Thank you.
Representative Graves has a question to your right.
Thank you, Mr. Chairman. Just if you could help me clarify, I appreciate your explanation, but it was in lawyer terms, and some of us from Ranger need a little bit different explanation. Because there's one section that causes me to pause, and hypothetically, if an elderly lady were minding her own business, driving to town to get groceries, and somebody who was reckless, potentially DUI, hit her, and she was injured, this is saying that even though she's innocent, she did nothing negligent or reckless, that she would be, in a sense, liable for her own damages just for the fact that she didn't have a seatbelt on, yet she was hit by somebody who was reckless or potentially DUI or any other manner.
Well, liable, I think, is a different term than what you're talking about. What we're saying, there could be a lessening of what she would have as a recovery because of the failure to wear the seatbelt. That's what this bill speaks of. But
so
not liability. Liability.
That person who was abiding by the law, driving according to the conditions around them and obeying the speed limit, and yet was injured by somebody who was reckless, they would actually have responsibility for that themselves. And
Representative Gray, that goes to the very heart of what we talk about with the law that says you're now obligated to wear a seatbelt. We have that requirement in the law. We don't have the ability, though, that by your failure to have done so, you violate the law. Should you still be entitled to have the complete recovery in your situation, or should the jury, the trier of fact, be able to recognize that it could have been lessening of your injuries had you had your seatbelt on and take that into consideration? It doesn't mean they have obligation to reduce it, but they can consider that as a part of what they do in awarding damages.
And I agree with your point about the current law, but I think the law, in my opinion, was put in place so that we're protecting ourselves from ourselves, not necessarily protecting ourselves from someone else. In this case, what it appears to me is being done is that we're taking away the ability to protect an individual from someone else.
Perhaps you look at it that way, but I look at it beyond that. I say the whole idea behind what we do in laws, in many cases, especially what we call tort laws, tortfeasor laws, these type laws, is to encourage a type of conduct of people. And that's why I look at it from the standpoint of a public policy issue. Thank you.
So you believe by removing this from somebody who is innocently minding their own business, removing this is actually protecting them?
I think it's encouraging conduct.
Gentlemen's time has expired.
Thank you.
Well, there were only 13 more questions and 2 speakers. Representative Hatfield is recognized to speak on the bill.
Thank you, Mr. Speaker. You know, as I approach this bill, I think back to law school, and one of the things, the first part of our tort law class, one of the things that we talked about was called the eggshell skull doctrine. And that was a rule that said that if you're an actor and you act negligently, that you take the plaintiff as you find them. And the fact that the plaintiff might have been somebody who had an eggshell skull or was particularly prone to injury or to damage did not allow you to reduce that person's recovery or prevent them from recovering simply because they were more prone to injury or damage than an average person would be. I kind of use that or look at that rule and think about this bill, and I look at this bill as really what it is. This is a bill to help big insurance companies. This is a bill which, with all due respect to our insurance companies, it's going to allow insurers to come in every automobile case and litigate the question of whether or not a person was or was not wearing their seatbelt. And if they argue that they were not wearing their seatbelt, then it's going to allow the insurance company to try to diminish or deny a recovery to a plaintiff who may be completely innocent, completely without fault in causing a wreck. I don't see that that is a proper vehicle to get civil justice in this state. I would argue that this bill puts all the advantage in the court of the insurance company. If you'll look on the second page, starting at line 24, subsection C provides that the party offering such evidence proves by expert testimony that the injured party's failure to use a seat safety belt contributed to the injuries claimed by the plaintiff. And what all that means, aside from the lawyer speak, is that the insurance companies will be required to have experts in every one of these automobile cases where they want to litigate the issue of a seat belt. And ladies and gentlemen, it doesn't matter if you were wearing your seatbelt or if you weren't wearing your seatbelt as a plaintiff, because the insurance company is going to be able to come in with their expert. And you know, that's the old saying was, who's the expert? Expert's a guy from out of town who's carrying a briefcase. But the insurance companies will have these people, experts on retainer, for each and every automobile case, mark my words. And those experts will come in and they'll say, well, I know that the police report says that you were wearing your seatbelt, but you know, I really don't buy that, because I look at the injuries and the kinetics that were involved in this wreck, and the injuries are inconsistent with the plaintiff having worn a seatbelt in this wreck. And it wouldn't make a difference if the offending driver was DUI, if they were on drugs, or what they were doing to be at fault. The insurance company is going to make that argument. And they're going to say, ladies and gentlemen of the jury, if you find...
Gentlemen, suspend just a minute. Let me try to get a little order. Members of the House, please give your attention. If you have a conversation, take it to the ante room. Gentlemen, continue.
They're going to say, ladies and gentlemen of the jury, if you believe our insurance company expert that this plaintiff was not wearing a seatbelt, then you need to come back and return a zero verdict. That's what the insurance companies are going for in these cases. You think that this is not going to contribute to the cost of litigation in this state? I mean, everybody complains about the cost of litigating in the courts of this state in civil cases. But this is going to require, if an insurance company has an expert on retainer that they bring in to use in the case, then if the plaintiff and the plaintiff's attorney doesn't dig down and hire their own expert, come up with the funds to hire their own expert, then you, as a plaintiff, are going to be out of luck. Because that insurance company is going to have their expert. They've got the deep pocket, they've got the resources to beat you in every case. Whether they're representing somebody who was merely negligent or whether they are representing somebody who was DUI or on drugs. That's what we're dealing with here. This bill It's not about equalizing the playing field.